What is the burden of proof in whistleblower cases? Imagine risking your job to report something wrong at work. How does the law decide if your report really caused your employer's reaction? That's what we're here to find out. In whistleblower cases, the process of proving what happened is called the burden of proof. It's like a game where the employee and employer each have to show evidence to support their side. The first step is on the employee. They need to show that their protected activity, like reporting illegal or unethical conduct, was a contributing factor in an adverse employment action. That means even a small link, like a report made just days before a firing, can be enough. The standard here is called preponderance of the evidence, which simply means it's more likely than not that the protected activity played a role. This low standard is meant to encourage employees to speak up without fear of retaliation. It doesn't require proof that the employer definitely retaliated, only that the whistleblowing contributed to the negative action. Once the employee makes this showing, the burden shifts to the employer. Now, the employer must prove by clear and convincing evidence that they would have taken the same action regardless of the whistleblower's report. This higher standard means the employer needs solid proof, like documented performance issues or consistent application of policies, to justify their decision. They can't just say they had a good reason. They must show that the adverse action was inevitable even if the employee had not reported anything. This two-step process helps balance the rights of workers and employers. For employees, it's about establishing that their protected activity was a factor in the employer's decision. For employers, it's about proving that the decision was based on legitimate reasons, not retaliation. In practice, employees can support their case with timing evidence, such as the adverse action happening soon after the report. They can also point to inconsistent explanations from the employer or compare treatment with coworkers who did not report misconduct. Employers, on the other hand, should keep detailed records of performance issues and follow consistent disciplinary procedures. So, the core idea is that in whistleblower cases, the employee first needs to show that their protected activity played some part in the adverse action. Then, the employer must prove that they would have made the same decision even without the whistleblowing. This approach aims to protect workers who speak while giving employers a fair chance to defend their actions.